Hey everybody, Derek Christensen here. I'm an estate planning attorney in Dallas, Texas. Today I want to talk to you about what do you do with a signed estate plan after you got everything good to go. What do you do with those documents? So before I dive into that, just wanted to let you know how to reach out to me. You can reach out to me at my email, Derek, D-E-R-E-K, at legionlawpllc.com, or at my website, www.legionlawpllc.com. So with that, let's dive right in. It's actually a common question that I get with people who are just signed everything. They want to know, what do they do? Because some people are under the impression that you need to file your will with the government. Others believe that they have already filed their estate plan with the government, so you should just be able to access it as public record. Others, they don't know. They just don't know. So at the end of the day, this is my personal opinion on it. You don't have to follow it, but I believe that there's not much you need to do after you've signed your documents. That's it. Once you've signed your documents, generally speaking, there's no requirement to file your documents with the government to make sure somebody can access it. It's not like a deed where you have to file it for it to be effective. You can just keep it to yourself. It's a private document. It is in your binder. It's in whatever location you have it. And you keep it there until it's necessary, until you need it. So the documents of an estate plan usually consist of a will, a trust maybe, then there's going to be other documents that apply to whenever you're still alive, such as a medical power of attorney, HIPAA release form, advanced healthcare directive, all that stuff. Every single one of those documents, as long as they're signed correctly and notarized correctly, they are effective once they are signed. That's it. There's no requirement whatsoever to file your will with the government in Texas, no requirement for a financial plan or a financial power of attorney, nothing. So at the end of the day, just keep it yourself, keep it in your binder, keep the binder in a place that you can easily locate it, let loved ones know where to locate it, and make sure it's accessible, but not readily somewhere inside the house that it might get destroyed. So I tell people, keep your estate plan where you keep your insurance documents, your social security card, important documents like that. I would not recommend putting it in a safety box because safety boxes require a key or a code to get in, and loved ones might not have those things. And if they cannot access those documents, then effectively those documents don't help you. So that is what I personally do. That is what I recommend most people to do, is just simply keep it somewhere that people can locate it, let them know how to locate it, and that's it. But there are some other options you do have. I believe there's something called pre-probate where you can file your will with the government before you probate. You can open up a case, file your will, wait until you pass away, and then come back to the case and let it keep happening. That's a little preemptive. That's a little bit of a waste of time and filing fees, in my opinion. And I'm not really sure how to do that. It's very, very rare to do that. Additionally, the other documents that you might want to actually give to others is an advanced healthcare directive, your financial power of attorney, your medical power of attorney. You might want to give those to your doctor beforehand so that the doctor can keep it on file and be able to access it much quicker than if the document is in a binder at your home that somebody needs to go grab. That is an option, but it's not required. And again, those documents are effective as soon as you sign them. So in theory, if you give it to the doctor beforehand or if you give it to the doctor after you need it, it doesn't matter. It's still the same. They're both effective. It's just a matter of preference to find it quicker. So these are options that you can undertake, but again, they're not required under the law, at least in Texas. And because they're not required, I recommend people just simply keep it to yourself, make some electronic copies, keep it in your binder, let people know where to find it, and at the end of the day, only use those documents when you absolutely need to, because you don't want to lose them. The original signed copies are extremely important. And if you happen to lose the original signed copies, then you actually lose the entire document itself. And sometimes, in some circumstances, an electronic PDF version of the document scanned in is not effective, including wills. So you cannot use copies of a will to effectively be the will. It has to be the original signed actual physical copy. So either way, that's all to say. Treat these original documents with holy respect. Keep them in somewhere where you can find them. Keep them where somebody else can find them. But at the end of the day, it is not required to file them in any capacity. You do not need to go to the government and give it to them before you've passed away or before you need them. So that should spell that out. It should be a little bit easier to do that. And again, as long as you can access it, as your loved ones know where it's at, they are going to be just as effective as if you filed them beforehand, and you get to save yourself some time and money. So that's that. And if you lose those, then you probably need to get them replaced. And if you need to get them replaced, I'd be more than happy to help out on that front. If you need any more advice on where to store them or to whom you need to give them as well, attorneys help out on that front as well. So again, you can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me at my website, www.legionlawpllc.com, and we'll catch you guys on the next one. See ya.